everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and this week I'm away, but I'm still doing videos trying to help as many injury victims and families as I can, as that is our mission and our goal. So today we're going to do a last week tonight where we answer your questions and we talk about your comments. So the first comment I see in my YouTube comments feed is, can a regular person look up verdicts? And they're responding to my recent video, Who You Hire Matters, and it's a cautionary tale. So you could check out that video. That's a very interesting video. But the response to this is yes. I mean, a regular person can look up prior verdicts and settlements, for example, for a specific attorney, or you could search a specific injury in a specific venue. For example, I could search Atlanta, Georgia, and I could talk about fusions from a truck crash or fusions from a slip and fall. And I could see what the verdicts have been in the last 5 years, or I could look at all the verdicts that they have in the database. And there are different databases like LexisNexis, Westlaw, and there's also the Jury Verdict Reporter. But the issue is that while an individual can do it, it's probably going to be expensive because a lot of these databases are pay to play, meaning you have to subscribe and you have to pay. And some of them, I think like Lexis and Westlaw, you have to be an attorney. Now, I'm not sure about the Jury Verdict Reporter. That's like a big company called ALM. It's the same company that produces the National Law Journal and the New York Law Journal and other publications. It may also be, only for lawyers. I'm not sure. I'd have to look into that. But I'm willing to do it for free of charge for people if people have that question, or reach out to me, just 347-566-9595, because I feel like that's one of the things that I can do to help. So I'm happy to do that. Okay, let's see. What other questions do people have? Some comments. Somebody here says, pay attention to video editing. Yeah, we're actually going to do that. We actually hired a video editor in-house. So you're going to see our videos are going to be edited a little bit nicer. Because in the past, including this video, because I'm away now, so what I've been doing is just kind of shooting it on my iPhone. I press start, I press stop. But in the future, we're going to do a little bit more editing with some B-roll and some transitions, or we have a really nice video editor. He's joined our team. He's part of our law firm now. So that's going to be exciting. And what other questions? Here's a question from TR. He says, I have a bad attorney. He's trying to sell my case out. He keeps using trickery to sell out my spinal cord injury. Oh, I'm so sorry to hear that. Yeah, just text me, 347-566-9595. I'm happy to chat, provide you with any guidance, any help, whatever you need. Okay. And William Smith says, if you don't include legal costs in your settlement, then you got the wrong lawyer. Yeah, I mean, legal costs, if you're talking about disbursements or out-of-pocket expenses, they come off the top. So for example, if a case settles for $1 million and the lawyer has spent $1,000 in prosecuting and handling the case, $1,000 will get deducted, right? So now you have $999. The lawyer takes his third, which is about $333,000, and then $667,000 goes to the client. So that's how it works. And then we have a video here, how to win a motion for summary judgment. And someone says, what if the plaintiff wins it? Yeah, so a motion for summary judgment is when a party, it could be a plaintiff or a defendant, they basically ask the court to issue a judgment as a matter of law, known as a summary judgment, a quick and summary, because what you're doing is you're making a motion and you have an attorney's affidavit, but you could also have affidavits from witnesses. You have to tender evidence, right, in admissible form, much like you would in a trial. So you could have affidavits, you could have photographs, you could have certified police reports. And what you're essentially saying is there's no issue for a jury to decide. There's no question of fact, because juries decide facts, right? Who's telling the truth? If I say I had a green light and the defendant says, no, I had a green light, well, one of us is lying. And the jury has to then, see who's more credible and which one of us is lying. But if I was stopped at a red light and I get rear-ended and I was stopped for, let's say, 10 seconds, well, now what's the issue of fact for a jury to decide? There is none, right? So if I say, look, I was stopped for 10 seconds, it was a red light, everybody was stopped, and this truck came from behind me, he just didn't, I guess he didn't see it or whatever, he was on his phone, he rear-ended me, they're 100% at fault as a matter of law. So the good thing for the plaintiff to file this motion is that you can get 9% interest on any future judgment as to your damages. So if I file the motion now, let's say in May of 2024, right, I can get the decision sometime in May of 2024, like in 2-3 weeks. But then I might not go to trial until 2026. But in 2026, the jury might say, you know what, this is worth $1 million. But now it's worth $1 million plus 9% interest back to May of 2024. You know, each year for 2 years, 9% interest in New York, at least. In every state will have a different interest, but you can look into that. But so I think that's good to do for the plaintiff. Okay, and then we had this video where we talked about personal injury attorneys and clients, what they can learn from the show Ted Lasso. And somebody said, hey, Mr. Arkady, need your help. I have a cervical stenosis and myomalacia and some kind of revision surgery, San Francisco, bad diagnosis. And the lawyer says the company's only going to pay me $99,000 and there are herniated discs. Yeah, no, I'm happy to chat. Just text me. You know, it's hard to say. I'd have to chat with you and look into the injuries a little bit more, and I can give you my personal opinion. And someone else says, therapy to injections, legal value of my case. I mean, it's hard to say just from, you know, a quick comment like that, but I've got, just injections, I've gotten $150,000 and more just for injections in the past. Okay, and how about this video? How much? All about damages, verdicts, and settlements, the 2023 update. And someone says, I got hurt on my job trying to restrain a youth that punched me in the face, and I grabbed him and we fell. I tore my rotator cuff. I had surgery. What kind of settlement do you think I will receive? I mean, it's hard for me to say that kind of case because that sounds like a straight workers' comp. So that's a work accident. There's not really somebody to sue, because if you're trying to restrain a youth and that's part of your job, because you're working like in a youth center or I don't know, some kind of juvenile detention, whatever it was, a hospital, and you're trying to restrain somebody and then you just fall because they punch you. So that's a workers' comp. That's a work incident. That's a straight workers' comp. Now, sometimes you could have a work incident. Like, for example, I'm working and I have a slip and fall at work, but I fell because of a puddle, but the puddle wasn't caused by my employer. Like, say I work for ABC company, but rather the puddle was caused by XYZ cleaning company, an outside third party. XYZ cleaning company came in and they're mopping the floors in my workplace and they leave a puddle. So now I have a workers' comp and they're going to pay my medical bills and they're also going to pay my lost wages. And I could do it with, in New York, at least a Section 32 settlement for the workers' comp, like a lump sum. Plus, I could sue XYZ, the third party, in a personal injury lawsuit. But here it doesn't sound like that because it's this youth that punched him, unless, you know, he could sue the youth, but I don't think the youth is going to have any money or any assets. So that sounds like a straight workers' comp. Now, I don't do straight workers' comp, but I'm happy to help with them. I know a lot of lawyers that do, and I could refer you. So yeah, I'm happy to help. Okay, how to get $3 million on a soft tissue car accident. And someone says, my wife had an accident and had positive MRI for a bulging disc. She also has radiculopathy and constant pain. Now the insurance is offering $1,000. What can we do? Well, I would say, you know, definitely get a lawyer, a good trial lawyer. You know, $1,000 is ridiculously low. So if you have bulging discs, you have proof, especially radiculopathy. Now, radiculopathy is shown through EMG NCV testing, which is objective testing. So they can't say, hey, you're making this up. Subjective, if I say, I feel pain, but somebody else might say, well, he's saying he feels pain, but how can we really test? So you need these objective tests. Now, EMG NCV, they hook up these little pads to you, and the electric current goes through your body. And so if you have an injury to the neck, it's going to travel or radiate to the hands. If you have an injury in the lower back, it's going to travel or radiate to the legs, including sometimes the toes. So if you have that and it's documented, it's done through fibrillation potentials, like you hear it, the sound, and also through those charts, like they go up and they go down, and then the doctor will interpret that, usually a neurologist. So if you have that, then yeah, I mean, that's an objective evidence of radiculopathy and a spine injury. So that's going to be worth more than $1,000. I don't know. That sounds like they're really lowballing you. So I would consult with a good attorney. And then in response to this short, where I say be a goldfish, That's also from that Ted Lasso show. So what I meant by that was be a goldfish. You know, if something happens, like for example, you show up in the morning to court and for whatever reason, the judge is in a bad mood and they lambast you and yell at you, or, you know, don't let that linger. Don't have that anger inside of you. Just let it out, like breathe it out and start anew, start fresh, be like a goldfish. You know, don't remember these bad things, because then the judge will respect you more. They'll say, look, this lawyer is doing their best. They're not harboring any ill will. They're not remembering any or holding any grudges or remembering any, you know, incidents, but rather they're doing the best thing for their client. So this person says, goldfish only have a bad memory and lifespan when humans put them in a glass bowl. So I thought that was funny. Yeah, that's true. Okay, what personal injury attorneys and clients can learn from Ted Lasso? And someone says, when a defense lawyer withdraws his entry on a lawsuit, does it slow the litigation process? And what would be a cause for an attorney to do that? So yeah, I don't think they can do that. If an attorney is already defending the case, that means the insurance company hired them to defend. Now the insurance company could fire them and get another law firm to defend, but I don't think they can just leave once they've started defending. I don't believe so. I haven't really heard of that. So we'd have to get a little more information as to what's happening there. Okay, and then somebody here says, I have a question. Why would it's the same question. Okay, so people ask the same question in different videos. Okay, here's a question. Awesome content, learning a lot. Before my incident, was seeing a mental health professional for over 6 years, but after my incident, I stopped going, seeking the help I was getting to control my anxiety, depression. It's been 9 months since I've seen a doctor, but since late December 2023, my condition started once again, which has made many things more difficult. I'm thinking of going for help once again. Is that something I should do? Will this hurt my case, especially with the 9-month gap? No, I don't think it'll really hurt your case if you've been getting treatment. I mean, as long as you have a physical injury too, let's say it's a car crash, you have a physical injury, meaning you have, let's say, herniated disc, whatever, you have a physical injury, then you could add a mental suffering or emotional suffering component on top of the physical injury. So then you'll have both. That's permissible. So yeah, that's probably the best thing to do. Okay. And then someone says here in response to the video, back injuries and your personal injury lawsuit, medical care and case value. Someone says, if you have policy limits, you are stuck. Meaning if the insurance company has already tendered the policy, meaning given you everything that they have, then you're stuck, you can't get more. And I say, look, well, yeah, but if the limits are high, you get everything there is to get. Now, if the defendant has low limits, like $25,000, you can try UM or SUM. For example, if you have higher limits, let's say you have 100, but the guy who rear-ended you has 25. You take their 25, now you can get 75 more from your own. You can get the difference because you have higher limits. You could also see if they have excess umbrella coverage beyond the primary limit. Some people might have 250, but then they have another million in excess or umbrella beyond the 250. You just have to request that in the litigation process. And you could also try to set up a bad faith claim where you open the policy. If you say, look, I'll settle this case for $25,000, and they say, no, we're not going to pay that. Well, now perhaps if you keep repeatedly telling them and you have in writing that you've shown them your injuries and you've given them an opportunity to settle within the primary policy and they've refused, now they have a duty of good faith and fair dealing to their policyholder, right? The defendant, the actual person who bought the insurance policy. So now if you go to a trial and the jury says, hey, it's worth $1 million. Well, look, they could have settled for $25,000, but now they blew that opportunity. Now the policy is open. Now, whatever I get in trial, some states will say they have to pay me the full $1 million. But that's a little complicated. There are 10 different ways to do that, or 10 different things that you have to usually have in the letters. But, we've been trying to do that in New York and trying to get the law improved in New York. In New York, our bad faith law is very bad for plaintiffs. And then the other thing, look, the final thing you can do is you can do asset searches to see if the defendant has a low policy but has collectible assets. If they have something that you can collect in a judgment, you can just go and get a verdict, and then, okay, they have a 25 policy, so you get the first 25 from the insurance, and then whatever you get above and beyond that, if you can collect it against them, right? If they have assets, property, money in the bank, you can just do it like a lawsuit like that. So there are options, but every case is going to be different. Okay. And then Notarant says, great video, Mr. Frecht, but I hope you're getting rest. I know we have many questions, but who am I to tell you rest is best? We need Arkady at his best. Yeah, so see, yeah, I listened to him. I'm here on a little vacation. So I'm gonna go now. I'm gonna go maybe hit the beach and take a swim, get a little rest. I'm gonna listen to this viewer. He's a smart man. But like and subscribe to our channel. Let us know what questions you have. We are here for you. And all the best, everyone. Okay, bye-bye.